Hello, everyone, and welcome. I see everybody trickling in. Please make sure that if you have any questions, you add them to the Q&A or put them on the chat. We do have some questions already that was sent to us. But if you have any questions at all, we're going to leave time at the end so that I can answer any questions that you guys may have. And if you have any questions right now that you're like, I already know I want to ask this question, go ahead and put it on the Q&A so that I'll make sure to get to it. Because I have a lot of information for you guys. It's going to be an overload. Let's see. Welcome everyone. And I guess we're just going to give everyone a few more minutes and maybe we'll start at 12:03. Yeah. Just 2 more minutes, because once I start sharing the screen, I won't be able to see much. Yes, and feel free to introduce yourself. Let me know if you are an immigration attorney, if you are, an attorney in any other area of the law that deals with immigrants, or if you'd like to make the transition into immigration. I sort of incorporated a little bit of everything with the anticipation that you guys were sort of all over, like new immigration attorneys, or someone that's thinking about getting into immigration law and sort of what to expect, like how some of these processes work. And so a lot of it is very simple. Some of it goes a little bit in depth, but I'm going to try to cover as much as I can in this hour. So welcome to Immigration 101, what every lawyer should know. I try to make this as broad as possible, and I'm going to try to make it as simple as possible. I am Pamela Peinado, and it is an honor to be speaking to you guys today about a topic that is near and dear to my heart, immigration. So I'm going to share my screen and we're going to get started. All right, let's see. Welcome, everyone. All right, I want to start the slideshow. All right, Immigration 101. So today we're going to talk about the basics and basically what to look for when you are representing non-US citizens. So that's me. That is an awesome little drawing that they made of me. And it's one of my quotes, which is, I do what I do because I am an immigrant. I love immigration. This is, what I'm passionate about. I would do this for free. I do it for free. So this is everything to me. A little bit about me. For those of you that don't know me, I was born in the Dominican Republic. I came to the United States as a green card holder. I am the first and only naturalized citizen in my family. My stepfather was deported as a teen. I've worked in this field for over 15 years. My uncle was detained by ICE. He was at the Stewart Detention Center. And my firm was able to win that case. So, I experienced firsthand like what the other side feels, right? What's going on, the delays, the frustration. I'm the youngest and only female partner at my firm, and my firm represents cities, hospitals, churches, athletes, big companies, small companies, children. We do it all. We do everything immigration. We have about 5,000 active cases right now. A lot of my clients have my cell phones. They call it nonstop because I know that immigration is everything to them. I've appeared on CNN, ABC, NBC. I just say that so that you guys know I know my stuff. Immigration is what I do. I've served as keynote speakers in so many places, and I am honored to be here at the State Bar talking to you guys about my life, which is immigration. So in today's agenda, again, we're going to make it very simple as I possibly can. And at the end, I'm going to answer all the questions that you guys may have, but I have a lot to cover, and I'm going to try to talk as fast as possible so I can cover everything. But we're going to talk about immigration lingo, very, very important, most common immigration forms, questions that attorneys should ask their clients, the difference between visas versus stays, non-immigrant visas versus immigrant visas, marriage-based green cards, which is probably what I get asked about the most from other attorneys, citizenship, and we're going to discuss a little bit the criminal activity part of it for some of my criminal defense attorneys, which I get calls from criminal defense attorneys, public defenders, prosecutors all the time. And I enjoy it because I would much rather you are proactive about the immigration consequences of criminal pleas, then now we're trying to do something later on, trying to fix it. Okay, so we're going to start with immigration. And can you guys all see it? I think so. Yeah. Okay. You guys can see my screen? Yes. Okay. So we're going to start with immigration lingo. The most important thing with immigration, everything has an abbreviation. Everything, it's like an alphabet soup. So if you hear immigration attorneys speak, we're always talking in A's, B's, C, D's, E's, F's. I mean, it's all of these abbreviations that you must know if you're going to go into the field of immigration. So for example, when I say a B, it's a visitor. That's immediately what I'm talking about. The B's that are here is a B visa. It's a visitor visa. You got the BCC, the DACAs, which I'm sure you guys know a lot about. The EAD, which is an employment card. That is what most of my companies and clients, that is what they care about. They want an employment card because they want a social and they want a driver's license. When you hear the term EWI, that's EWI, it means you entered without inspection. When you hear the term F as a student, of course, you guys know about I-9s, I-94. The J, whenever you are dealing with an immigrant and they're here on a J, you have to be very careful because for this exchange visitor visa, there's a 2-year residence requirement, which means that, and we'll talk about this a little bit more later. Let's say they're here lawfully on a J, they get married. Can I get them a green card? No, because usually they have a 2-year residence requirement, which means they have to go back to their country before they can get a green card. That's one of the sort of nuances, right, in immigration. But any other lawful way of coming in, usually if they marry a US citizen, you're able to get them a green card here in the United States. Of course, you guys know the K1, 90-day fiance. Who hasn't seen that show? K1 is just a fiance visa. And the thing with that, as you guys know, they have to get married within 90 days. Okay, if they don't get married within 90 days, huge mess. If they don't marry their fiance, they can't get a green card. It doesn't matter what, if they come in as a fiance, they must marry their fiance. LPRs, that's lawful permanent residence. That's a green card. That's how I came into this country. So you're a permanent resident of the United States. You cannot vote. Don't you dare claim that you're a US citizen. You cannot commit certain crimes, and you can definitely get deported as a green card holder. I have a lot of clients in deportation proceedings that are green card holders. There's the R, religious worker. So we represent a lot of churches, pastors come from all over. There's T's, which are victims of human trafficking. We do a lot of those visas. And there's also the U visa, which is very important. I want all of you guys to know about this visa, especially my personal injury attorneys, right? Because they call me and they're like, you know, my client was a victim of, you know, a shooting, but they're illegal, they're scared. We can get them a visa for having been the victim of a crime, so long as they assisted with the investigation. So that's huge. In the old days, we used to have immigrants that were scared to come forward because they didn't want to come into contact with the police. They didn't want to give them, you know, their status that they're here illegally, and fear for deportation. Well, now, if you come forward and you assist, right, with these proceedings, with this investigation, you qualify for a U visa, which can turn into a green card. Now, we're talking about a 5-year, 8-year process, but you get in line and you're able to adjust your status based on this horrible thing that happened to you. So, you know, I want you guys to always be on the lookout for, you know, if you're dealing with a client and they suffered an injury, or generally not on the job, no, it has to be a personal injury that happened to them and it has to be covered. They can qualify for a U visa, get the employment card, get a green card. USCIS, when you hear that, all that means is just US Citizenship and Immigration Services. We deal with USCIS for everything, unless you're in deportation proceedings, and then we deal with EOIR, which is the Executive Office for Immigration Review. And then we have VAWA, Violence Against Women Act, and it applies to men as well. So if you're the victim of abuse by your US citizen spouse, you can also get a green card. So, you know, these are things that, again, I just want you guys to know, or if you hear it, it doesn't sound foreign to you. These are probably the most common, I guess, lingo of immigration and the ones that we use the most often. So immigration, everything that you do with immigration has to deal with a form, right? So you have to file a form with supplemental documents, usually a filing fee, and you send it off to USCIS. Okay, everything that we do with immigration, it's paperwork, it's form-based, it's, you file it with the supplemental document and then you wait. All right, so these are the most common forms that we deal with. It's the I-90. Again, remember I told you about the alphabet soup. So we talk about these all the time. Your green card is getting ready to expire, file an I-90. And the way that you do that is you would go to uscis.gov. Everything is on there, all of these forms. So immigration is wonderful because, let's say you're a sole practitioner, you can fill out you don't have to buy an expensive software or program, which my law firm does have a software and program. But if you're starting off, you can go to the uscis.gov and it has the form, right? And you can fill it out for the clients. A lot of these you can fill out online. I personally like to print out my forms, attach all the supplemental documents and send it off to immigration and then keep a copy for myself. So I-130, the petition for alien relatives. So if you have a parent, a child, a spouse, that's what you would file. Travel documents is an I-131. I-134 is an affidavit of support. The I-485 is the most common. So it would be I-130, the petition. So if you're married to a US citizen or if your parent or child, you would file an I-130, whether they're abroad in another country or they're here in the United States. Then the second most common, 485, that's a green card application. But you got to be very careful, obviously, because you don't want to file a green card application and end up in deportation proceedings because you didn't qualify or you didn't really, you were not eligible, but that is the form for the green card. Then there's a 539, which is to extend the non-immigrant status, and we're going to talk a little bit more about that. Then there's the, a bunch of them, the employment card, the 765, and we're also going to talk a little bit deeper about the N-400 application for naturalization. But remember, guys, all of this is on the uscis.gov website, and you can read, obviously, how do you qualify, what is it for, what should you add, or to the application as supporting documents. So questions that attorneys should ask their clients always. Number one, are you a US citizen? That is, and I know some of my colleagues, they call me and they say, Pam, it's a little uncomfortable to have that conversation. Have that conversation, right? You must ask it because it affects everything, okay? Are you a US citizen? And sometimes clients would say, yeah, but they're maybe waiting for an oath ceremony. So they're not a US citizen because they haven't been sworn in as a US citizen. And if you plea them or if they get a DUI, now they're not eligible to become a US citizen. So it literally changes everything. So very, very important. Ask them, are you a US citizen? Do you have a US passport? Do you have a certificate of naturalization, a certificate of citizenship? Do you have a US birth certificate? I know it's so simple, but it would eliminate so much problems in the end, right? And if they're not, if they say, no, I'm not a US citizen, then what is your lawful status, right? Because, as attorneys, we want to help, right? We want to make sure that we look at everything in the case. Do you have an immigration attorney? Because oftentimes when attorneys call me for my clients, the client has told them something completely different, right? And then I'm able to explain, no, we're in the process of doing this, this, and this. And it affects how other attorneys, family attorneys, personal injury attorneys, workers' comp, anything, how they operate based on what we're doing in immigration. Also, another question to ask is, do you have an immigration application pending? Very important, right? Because if they do have an immigration application pending, for example, and they're in the process of getting a divorce, we may want to be, strategic on that. If they do have that pending, if it's been approved, then you can proceed as you need to. But if there's an application pending, again, it's really good to speak to the immigration attorney so that you don't do something that's going to end up, causing the client to get deported. And again, the other one, which, I'm just surprised by how many times I tell this to everyone. And a lot of my friends still don't know that if they have been a victim of a crime, they qualify for that U visa if they assisted with the investigation. we can get that going. So I would say those are the questions that, everyone, all of you guys, all of my colleagues, all of my friends should know. Do you have lawful status? Do you have an immigration attorney? Is there something pending for you that I should know about? And have you been the victim of a crime? All right. So do you have lawful status? I have some clients that come in, and even when we ask the question, they say, yeah, I have a visa. It's like for 10 years. Well, there's a huge difference between a visa and an authorized stay. And I want to make sure that all of you guys understand that, right? You can have a visa, right, which allows a foreign citizen to come to the United States. It could allow you to come multiple times. And basically, it just says you're eligible to come in. But your authorized stay is what you're authorized to stay, right, by a U.S. immigration officer. And for the most part, you're usually allowed to stay 6 months. But I always tell the attorneys, if they're looking at a case like this, if they're doing this case pro bono, if they're trying to learn, to always check. Okay, I had a client come to see me and they said, my stay expires in 6 months. We went on the I-94. So if you go to CBP I-94 website, you can put in the biographic information, the date of birth, and it'll tell you. And it was 3 months. Okay, they were only authorized to come in 3 months. And what that means is usually that when they came in, the officer, they have discretion to give them 1 month, 3 months, 6 months, and say you have to go back. And there was something about it that they maybe just didn't like. Because for the most part, if you're visiting, you usually get 6 months of an authorized stay. And why is this so important? Because, when you come in as a non-immigrant, and by non-immigrant, I mean someone that's coming here on a temporary basis, right? This could be a tourist. This could be someone coming in for a seminar. You're coming in to work, for some business meeting, study, anything like that that's temporary. Although the visa can be anywhere from 3 months to 10 years, and you can enter multiple times, again, for the most part, you're authorized to stay, especially as a visitor, for 6 months. And visitors are what we most encounter. Okay, now students, obviously, they come in as a student, they're here for the duration of that status. So as long as they're a student, they're good. Visitor, Bs, right, B1, B2, generally is 6 months of authorized stay. Okay, and you can request an extension of that 6 months one time, and it's granted at their discretion. And again, the way that you would do that is you would file a form. Everything is form-based. So you would file the form I-539 before the stay expires, because if you are here, okay, so let's say you come in January, your stay is authorized till June or, whatever date, June 1st. If you overstay past that authorized day, you are accruing unlawful presence in the United States, okay? And what that means is that not only can you get deported, but if you leave and try to come back, they will tell you that you have a bar from coming back into the United States because you were unlawfully present in the United States. So what does that mean? What does that look like? So let's say you're here. Now, obviously with COVID, we've been able to, explain to USCIS, they overstayed, it was beyond their control. The planes were not going out, they were sick, they were this, and then they leave, but we're able to have that documentation. The best thing to do is to file for an extension before that stay expires with that form via the USCIS.gov website, right? The I-539. But let's say the client comes to you and they're already here and they're illegal. You got to let them know. If you've accrued more than 180 days of unlawful presence here, but less than 1 year, right? So you've been here, your stay expired, and it's been 180 days, you're barred. If you leave, the moment that you leave the United States, you're barred from coming back for 3 years, okay? And if you're here for more than a year, unlawfully, past your stay, you're barred for 10 years. I mean, this is huge for someone that has a visa for 10 years, right? And they can come back and forth, no problem. And maybe they just didn't know. this is so important. I want all of us attorneys to know that way. If a client comes to us and we're like, okay, you're here as a visitor. Well, do you know when it expires? A lot of my clients, they say, oh, I don't know. I think 6 months. We look online 3 months. And they could be accruing unlawful presence. And now the moment they go back, that bar is triggered. And they try to come for a wedding, for a birthday, for anything. And at the border, they're, the CBP officers know you've been barred from coming in for 3 years because you overstayed. So very, very important information to give to clients, or to have them speak to an immigration attorney if you feel like they're coming close to their authorized stay expiring. So what is a way that, let's say a client has been here as a visitor and they overstayed, and it's been years and they've been here, right, without status. You cannot get them an employment-based visa or anything because they're out of status. The only way, for the most part, is for them to get a green card via a marriage to a US citizen. Okay, so that is why a lot of attorneys ask me, okay, what's the process for, if you get married to a US citizen? So you must have entered lawfully, whether it's B, again, visitor, F, student, anyway, border crossing card, you enter the United States lawfully. And even if you are here past your authorized stay, immigration forgives it because you're married to a US citizen, okay? What I want you guys to look out for, again, it's that J visa, lawful entry. So if you ever see it, know that they can, more than likely, unless that has been waived, they will have to do 2 years abroad and then come back in order to get a green card through marriage-based. If they were here illegally, another way that they can get their green card if they marry a US citizen is if there was a petition that was filed for them before April 30th, 2001. That is the magic date. So if a client crossed the border, they're here illegally, anything of that sort, if, God willing, maybe a sister or someone filed for them any petition before April 30th, 2001, that's something to look into because they may be eligible to adjust status and get a green card. And for those of you that maybe have never done an immigration case, adjust status is huge because it gives you an employment card, gives you a social, gives you the ability to stay here in the United States while you apply for a green card based on this marriage. If you entered illegally, you crossed the border and you marry a US citizen, you are not able to adjust status to a green card here in the United States. They won't allow it unless you came in lawfully, unless you have that petition from 2001. So that process is not an adjustment of status. You can still get a green card, but it takes years and you have to go abroad. And you can only imagine, because if you send that client abroad, God knows what can happen at that interview, with that consular officer. You never know what they say. You never know what they do. Here, adjustment of status means I'm adjusting your status from a visitor, overstay, or even a visitor that's still in invalid status to a green card holder, right? And you can do that if they're married to a US citizen. If they came here lawfully, you follow this application and then you go to the interview with them. So you can sit with them and make sure they don't say anything crazy and that they get approved. So who can apply? Enter the US lawfully, legally married to a US citizen. Be mindful of the 30, 60, 90-day rule. Basically means if you come in and you petition, you file this green card in 30 days, the presumption was that you entered as a visitor with the intent to stay, okay? So you entered as a non-immigrant, which means you're coming in temporarily, but if you file something within 30 days, immigration is gonna say, no. You came in with the intention of being an immigrant, which means you were permanently gonna stay. So you committed fraud. So we don't want that. 60 days, there's a rebuttable presumption, and then usually we file everything in the 90-day to be more in the clear. Okay, we've seen a lot of cases go away when clients file something immediately. You have no pending criminal case, no disqualifying convictions, no false claim to US citizenship, no voting, and no previous marriage fraud findings. I'm gonna go through this fairly quickly, but just so that you guys can get an idea because, some folks say, I'm married to a US citizen, I should have a green card. And it's not easy, right? You have to file a lot of applications and it's a process. So again, you file the form I-130, the petition for alien relative, I-130A, 485, the 765 gives you an employment card. I-131 gives you a travel document. You're only eligible for a travel document if you're here in valid status. If your status expired a while ago, they're not going to give you a travel document. Then you have to fill out an affidavit of support with evidence to show that you're not going to become dependent on the government for any financial help. And you include copies of birth certificates, passport, marriage certificates, divorce decree, a lot of documentation to show that the relationship is real, right? And not for immigration purposes. So joint taxes, a lot of them, the accountants, they'll call me and they say, do they have to file joint taxes? Please do, right? If you're in this process, in a marriage-based process. Now, sometimes it's impossible. So they have to file separate. That's fine, but we prefer joint. And, obviously little things like make sure everything has the same address. Sometimes one tax has one address, the other tax has another address, or W-2s. So these are things to look out for. You file a medical examination that immigration requires, passport style photos, certified dispositions for all arrests, and the filing fees. These are not the legal fees. These are just the filing fees that has to be paid to immigration. $12.25 and $5.35, and that's subject to change. So if you're filing for a green card based on a marriage, that's the filing fee that you have to include in your petition. So what's the process, right? You file the application with USCIS, you get a receipt. With that receipt, you can check the status of that application online via the USCIS.gov website. Then your client will have to go to a fingerprint appointment, make sure they don't have any warrants, any crimes. Then if you didn't submit a complete perfect packet, they will send a request for evidence. And usually it's like taxes, right? Like, send us all the pages of your taxes, send us criminal disposition, send us, your birth certificate wasn't translated. So everything needs to be translated. Then you submit that, you get the EAD, which means employment authorization document, which is what every client wants, so that they can work, they can get a social security. I-131 is a travel document, and then they can get their driver's license. So imagine the whole time they're here without a driver's license, without a social, struggling. Now, once you file this, you get in queue to get that employment card. Now, in the old days, we used to get employment cards in 3 months. Nowadays, we just never know, right? Like it could be 6 months, it could be 9 months. So we try to warn the clients that it may be a while. Then we got to go to an interview. That is the final step. We go to the interview where the attorney can go, an interpreter if necessary. You're before an officer. And I cannot stress this enough, how important it is, obviously, to know these officers, to get to know them, because, the same case with 2 officers goes completely different. And we know that, right? Like dealing with different prosecutors, different judges. So it's very important to prep our clients for the worst possible interview. And then you get an approval, denial, you get the green card in the mail. So now that you have your green card, what comes next? If you get a conditional green card, you got to apply for the permanent green card. But I want to talk to you guys about applying for citizenship, because I get so many questions about, why isn't he a US citizen? What's stopping someone from being a US citizen? And again, it is not as easy as it may seem. Number one, you have to get a green card. And you guys, that process, it's only if you're married to a US citizen. And it can take up to a year or longer, actually, right? Then you got to file another petition to remove the conditions on that green card. Make sure that the marriage is still valid 2 years later. And then you wait for that. And then you can apply for citizenship. So, sometimes I get clients that tell me, my nanny, she's been here forever, 40 years, never committed a crime, the best person ever, she should have her citizenship. I mean, you first have to get the green card, which is very hard to do, right? So you got the green card now. You have to be 18 years old. You have to speak, read, and write basic English, pass a US history and government test, meet the physical presence required, have good moral character, take an oath of allegiance. How do you do this? How do you file for citizenship? Go to the uscis.gov website, Form N400. You include a copy of the front and back of your green card, copy of your marriage certificate if it applies, divorce decrees, children's birth certificates, passports, certified disposition. If you're a male that has been in the country for some time, you have to make sure that you have that selective service. And if you're applying based on marriage to a US citizen, you have to include documents to show, again, that the marriage is real and that you guys are still living together. What you need to look out for: good moral character issues, selective registration issues with men. If they haven't registered, you just submit a letter explaining. Criminal issues, big problem. You cannot have any issues with the IRS, no issues with child support. A significant misdemeanor, we've had citizenship denied because of a DUI, if it's within that 5-year period. So if you have a green card for 5 years, you're not married to a US citizen or anything, you can apply for citizenship in that 5 years. If you have a green card and you're married to a US citizen, you can apply for citizenship in 3 years. Okay, so everything has to do with whether you're married to a US citizen or not. If you're not, then this is a 5-year good moral character. If you're married to a US citizen, it's a 3-year good moral character like parameter, right? So if you have a DUI within those 5 years, let's say you're not married to a US citizen, your citizenship can get denied, right? If you voted, huge issue. I have right now a 70-year-old client. She came to us, she said, I want to file for citizenship. She said, I'm going to do it on my own. We told her, don't do it on your own because anything can happen. She said, I'm going to go do it, but I'll let you know so that you can come to my interview. I said, all right. Next thing you know, she filed it. She calls me crying. I mean, it's like a year later. She said, Ms. Pam, I was trying to be honest. So I told them I voted on a local election. Oh my goodness. She's now in deportation proceedings because in a citizenship application, she put in there that she voted, right? So it's almost like, she put herself in this situation, right? Big issue voting, false claim to US citizenship, big issue. And we get those a lot when folks are trying to get driver's license. And, maybe the DMV individual doesn't ask, or, whatever happens, they put in their US citizen, that comes back. Also, if you have a green card holder as your client, always check their A number. The A number is what identifies basically all immigrants to immigration. So if you have an A number, you either had a petition, you had an application, or you've been before a judge. A numbers are so important. They're always on the green card. So what you need to do is you take that A number, online, there's an EOIR portal, you put that A number and it says, we don't recognize this A number, excellent. If it says, this is, we recognize this A number, this person was ordered deported in 1985, then you have a big problem. You cannot apply for citizenship. Sometimes in the green card process, they miss that. Then you get to the citizenship and you check their A number. Oh my goodness, they had a removal case way back when that nobody in immigration caught. Then you file for citizenship. It's a big waste of time. So always make sure that you're checking that A number, obviously before you file for the green card, but they could still give you that green card. Then you must check again because it may just not have been in the system at that time. And then it comes up, and then that way, So for citizenship, there's some conditional bars to it. It's an INA 101F. And it's basically, controlled substance violations, prostitution offenses, gambling, 2 or more DUIs, certain unlawful acts in that, again, 5-year or 3-year period. Then there are permanent bars, and we're going to briefly touch on them, which is you'll never be able to get citizenship. And in fact, if you apply for citizenship, you're going to end up in deportation proceedings if you have any of these crimes that are listed on INA section 101A43A. So what are the steps of that citizenship case that we were just talking about? You file the application with USCIS, you get the receipt, your clients go to fingerprints, they'll get a request for evidence if you didn't include everything. They go to an interview where they'll be tested on US history, the writing, their English. They get an approval. They're not a US citizen yet. I had a client go out after we got a very, very complicated citizenship and gets a DUI. after the interview. So no, I mean, now we can't get to the oath ceremony and we can't become a US citizen because you had a crime in between. You're only a US citizen after you get sworn in as a US citizen and you have a certificate of naturalization of citizenship. Very, very important. And as much as I stress it to the clients, sometimes they let you down. All right, so some criminal activities that you have to be on the lookout for. And I get these calls all the time. I'm going to try to make it as simple as possible. So these are crimes that make you inadmissible. So you're trying to get green cards. You won't be able to if you have any of this stuff, okay? Most common are crimes of moral turpitude. They're like they shock the conscience, not good for the community. These are your theft, and these are just examples. Giving false names, forgery, damage to property, prostitution, etc. There is something called the petty exception, which I speak to a lot of criminal defense attorneys about. If your client only has one of these, right, theft by shoplifting, one ever, right, and it must be a misdemeanor because it must have a maximum penalty of a year, and your client was only personally sentenced to no more than 6 months imprisonment, then you're eligible for this petty exception. It's all good, okay? But if you don't meet the petty exception, then it will be a big issue. And that's why before you plea anyone out, definitely speak to their immigration attorney or try to figure out what is their status, because it can really, you might get them the best deal possible. For a US citizen, this is the best deal. But for an immigrant, you're basically signing off on their deportation. Okay, which is obviously, nobody wants. And especially that Padilla case came out where criminal defense attorneys have to advise of that immigration, consequences, and the clients must know, we want to make sure that they either speak to an immigration attorney or that you guys have someone that you can talk to, or that they understand what's going to happen if they take this plea. Obviously, controlled substances are a big one, and multiple criminal convictions with sentencing totaling 5 years or more. In addition, a lot of folks don't know this, but they can engage in certain kind of conduct that even if they were never convicted, they can still get deported. So we had a client, and he goes abroad, right? We do this long process, and we've gone over everything. Well, he goes abroad for his green card interview to come back in. The officer starts talking to him, says, what do you think about marijuana? I mean, I'm sure you've tried it. I'm sure you've done this. My client, oh yeah, done, right? Like he couldn't come back in because he admitted, right, to drugs, which is ridiculous, but it is what it is, and you got to follow the law, and it is at the discretion of the officer. So even if you are not convicted of a crime, conduct, anything that you do that is illegal, forget about it. And again, these can include prostitution-related activity, definitely drug trafficking, if they have a reason to believe. We have another client where never been convicted, never been arrested, but the house that he was in, his brother, there was some type of raid. So they used that to deny it. And we had to, uphill battle because they had reason to believe that he was a drug trafficker. No conviction, no admission, nothing. Just that the house was raided at some point by the police and the DEA. But mind you, he was living there with his family and his 5 brothers. All right. So these are the aggravated felonies that we talked about. Obviously, I mean, this is just the worst of the worst that you can have, or that you can plead to, trafficking and controlled substance. Now, obviously, I can teach a whole class on this because there are certain categories or certain subsections that could work. But for the most part, these will get you in a lot of trouble. The one that we see the most are crimes of violence, 1 year in prison. So a lot of times we see a sentencing document, a disposition that says, family violence, 12 months confinement to be served on probation. That's a crime of violence, 1 year in prison, even though the client never, stepped foot in that prison. The way that order is written, even though it says to be served on probation and all of that, causes a huge ordeal. And that is why I know a lot of you have heard, the 11 months, that's, the petty exception for the CIMTs, the 6 months. There are ways to get around it where you're literally not signing off on your client's, again, deportation order by taking this plea. Because once they take the plea, and let's say they see an immigration attorney, we're going to look at that and we're going to say, oh my God, this is going to, get you deported. So there's two ways to fix that. It's to file a motion to vacate that plea. And to do that, you have to say that the client was never informed of the immigration consequences of that plea, right? Or you could ask for a government pardon. Those are the two ways that we can fix any of these. So this is the whole list. You can find the whole list in the INA A43A. All right. So let's say you commit a crime, right? Or you get the denial of the application, the citizenship, the green card. That's going to cause you to end up in deportation proceedings, which is under the umbrella of EOIR. Okay. You can end up in deportation proceedings by, again, the denial of a green card of any application that you submit, or an ICE encounter, any crimes, any pleas, you're on probation, any CBP encounter, etc. You're going to get issued an NTA, which is a notice to appear. It's going to state your charges, and it's going to give you a hearing date where you're going to show up in front of the judge, immigration judge. You're going to have a master hearing. It's like a arraignment, right, for immigration proceedings. Very short. In the old days, I mean, there would be like 200 people there. It's like, just cattle call 1 minute or two. What are we going to do in this case? We're requesting asylum. We're asking for, we're going to file for a green card. We're going to do this. We're going to do that. Okay. We're going to set it for another master, usually a couple masters. You submit documents. Then you get your individual hearing. That's your trial, your bench trial. Immigration courts are a little bit more relaxed than criminal court. Everybody sits down. It's obviously a bench trial. There's not that many objections for the most part. And then at the end, the judge will issue a decision. He will either grant relief, grant the asylum, grant to the green card, or he'll deny it. If he denies it, you get 30 days and you get to appeal it to the Board of Immigration Appeals, right? Then you take it to the Board of Immigration Appeals. The Board of Immigration Appeals dismisses. You can file a petition with the 11th Circuit, and then you can, keep it going. Then in the end, ICE may enforce that order. So there are some resources that can help you guys if you're, new to immigration, if you're going to go into this field. The INA, all online, that's all the codes, all the criminal activities that I was talking about. Everything is on there, the INA. So you go online and you can see that. The CFR, the Code of Federal Regulations, Title 8, online again, and you can get all that information. Curse ban, it's excellent. Every immigration attorney that I know has a curse ban book. Very nicely written and organized so that you can sort through issues. Then also, because I've seen that so many people were having issues, just getting mentorship or knowing how to put packages together, but immigration was their passion. I actually created a university workshop. It's called the Immigration University. And we have Zoom calls like this. We just try to teach as much as possible, because it's really heartbreaking when I get a case, and I have to call my colleague and I'm like, why would you do this? Why would you put this person in such a peril, right? Like, why would you file this application that's going to get them in so much, that can get them deported? And they would say, I'm sorry, I just didn't know. So I think it is our duty to help each other. That's why these webinars are so important. Mentorship is so important. And how right nowadays, everyone is so busy that it's very difficult, right, to get a mentor in the field of immigration. So that's why I created the Immigration University. And we have, I think right now, maybe 20 students, and we do web calls, and we just try to help as much as possible. All right, let's see. So I'm going to go to the Q&A, but if you guys have any additional questions before I go to the questions that you guys submitted on the chat, that's my email, that's my website, that's our information for the Immigration University. And I'm going to stop sharing, and now I'm going to answer all the questions. I hope I didn't go too fast. Okay. Let's see. Oh, wow, there's a lot of questions. Okay, hold on 1 second. All right, so. So yeah, as long as they enter, so someone asked, a lot of these countries don't require a US visa. As long as they enter lawfully, they'll have that, right? Like there's ESTAs, as long as they entered in some type of lawful manner, they're fine. Let's see, will you add this question to the Q&A? Okay, I see. So the problem was that she voted, not that she disclosed it. Great question, great statement, Grady, yes. Trivia contest. And the problem is, if we would have advised her not to file that citizenship, right? She had a green card, right? So if she came to us and she said, I voted, you're filing, I mean, it breaks my heart. 70 years old, filing citizenship. That dream was always to become a citizen. She files this application. She discloses this information, which you're correct. Obviously, the problem is that she voted, which is, it's not okay because you're a green card holder. You're not a US citizen. And now she ends up in deportation proceedings for years. We've been fighting that case. All right, trivia contest will take place at the end. Awesome. All right, let me answer the questions that's in the Q&A. Can we get a copy of your PowerPoint presentation? Yes. Okay, what happens if someone comes in lawful entry and they're here for some time and it overstays? If you overstay, you can still marry a US citizen and you can still get that green card. That is the only way, because most times if you've overstayed, you're not eligible. So you could have a company that may want to sponsor you for a green card, but if you're here on unlawful status, you cannot get a green card. You have to be here on lawful status in order to get a green card via a company. The only way that you can be here without status is if you marry a US citizen. Okay, let's see. So this one is a little more specific, giving false name under a municipal ordinance. Oh my goodness. So I had a case similar to this and I had to file a motion to vacate because the charges were false name and false date of birth. And the way that the immigration judge, even though it was a municipal ordinance, the way that the judge interpreted was that it was 2 CIMTs. Even though we were arguing that it was the petty exception applied because it was less than 6 months, the judge said no, that it was 2. It was at the same time. So be very, very careful because it can cause problems depending on the judge. If you take any type of plea, anything that has to do with fraud or lying or anything of that sort, it can be considered a CIMT. Okay, for the 30, 60, 90 presumption of a non-immigrant entering the US with intent to marry, is this triggered by the date of marriage or the date of filing a green card? That's a great question. So we get a lot of clients that do come in and they marry quickly, and it's usually the date of filing that we go by. Why? Because you can get married because you want to get married in the United States and you can go back, right? So we can sort of explain that if that does happen. But filing of that immigrant petition, right, for that green card, how can you argue that? Like, let's say you enter 2 weeks, you get married in a week and you file it in a week. It's like, okay, we can say you got married in the United States if that is the case and you were trying to go back. But to argue that immigrant intent, it can get really bad. And we've seen it get really bad with the officers, right? Depending on the officers at the interview. All right, let's see. Okay, those are all the questions that I have. Does anyone else have any other questions? They'd like to type it into the Q&A. I think I've answered all the other questions I answered in the PowerPoint. Okay, for the immigration university courses, are they CLE? No, they're not. Just something I put together because I was just tired of speaking to the young lawyers over and over and saying the same thing over and over. So now I put them all together and I do a once a month webinar and I just answer their questions, just so that they don't run into any issues. Okay, let's see. All right, so I think I answered all of them. Does anybody else have any other questions before we wrap up? No? Okay. Well, awesome. I think now we can do the trivia contest. Thank you, Grady. All right, let's see. Oh, in recognition of Women's Month, who was the first woman to serve as a State Bar of Georgia president? Good question. No. Linda Klein. Yay. Good job, Stephanie. Awesome. Okay, do we have her information? Awesome. Your gift will arrive soon. All right, guys. Well, thank you so much for tuning in and sharing your lunch with me. I hope I didn't speak too fast. I hope I was clear and made it as simple as possible. I mean, we can talk about immigration for hours. So I'm here if you guys have any questions, and you guys have an awesome Tuesday. Thank you.